Amendments. We want to talk about amendments. There are 27 past amendments to the Constitution. The Equal Rights Amendment is still out there. It's been out there for decades, hasn't been approved by enough states. Remember, the first 10 amendments are called the Bill of Rights, and there were originally 12 proposed. 10 got adopted right away. One got adopted years later, which is limit on congressional pay increases, and still 12. Just a reminder of things that we has talked about before. The original Constitution didn't have a Bill of Rights in it, but the states basically refused to pass it. James Madison, who's up there, was in the Senate at the time of the Bill of Rights, and he took input from all the states basically and lots of other people and built the Bill of Rights that we have, built the 12 amendments that were submitted, 10 were approved. Again, Madison was afraid that we'd come to believe that our rights came from the Bill of Rights. Remember Declaration of Independence. We hold these truths to be self-evident, that all men are created with unalienable rights, right? All men are created. All men are endowed by their Creator with certain unalienable rights. You have these rights. They're inside you. You belong with those rights. If the government doesn't give you those rights, the government doesn't take them away. Madison was afraid that if we added a Bill of Rights to the Constitution, people would come to believe that the government could take those rights away because the government was providing. The Constitution was creating those rights, you could take them away. Madison believed both those propositions were not true. And he was afraid that we would come to believe that whatever the list was that we put into the Bill of Rights was all of our rights, when in fact we have more rights than are in the Bill of Rights. So the Supreme Court has found that there's a right to privacy that's implied in the Bill of Rights. If that's one of our inalienable rights, then we don't need it to be in the Constitution for it to exist. We can find it sort of in the Constitution if we want to. These are the issues. Amendment number 1. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably to assemble or to petition the government for redress of grievances. Congress shall make no law. Congress. So the original interpretation of the Constitution is that this applied to Congress. It did not apply to your state. Most state constitutions have free speech provisions in them, and we'll be talking soon about Nevada and see if we have one. Oprah Winfrey was sued in Texas for saying bad stuff about beef. They didn't win. Obviously, Oprah won. But originally, this thing did not apply to the state. It creates a separation of church and state, and we've been having all these Christmas arguments over time. Don't let anyone tell you that any president didn't say Christmas. Barack Obama said Christmas all the time. We celebrate Christmas at the White House. They put up a big Christmas tree. They do all that stuff. It's whether or not we're spending money. How are we taking taxpayer money and applying it to a church? Or are we somehow preventing people from practicing their religion? The Founding Fathers are very clear that they wanted the government and religion to be separate things. Okay? When someone says, hey, this was founded as a Christian nation, remember that God is not in the Constitution anywhere, that word. And that many of the people who opposed the Constitution originally opposed it because it had this really strict separation of church and state in it, that it's not that kind of document. It has all this free speech stuff in it, but remember, you can't go into a movie theater and yell fire. That's not covered by free speech. We all have rights. When our rights come into conflict, we create externalities, economists, externalities. Third parties are affected. Other people are affected. And so your exercise of free speech is limited by other people's rights. You can't violate someone else's rights while exercising yours. Now, this gets to be a big issue at places like universities, where universities across the United States have adopted these speech codes. There's a university, a major university in the United States, I won't tell you what it is, Michigan State, where you can't say someone's obese in class. You have to say they're a person of size. Now, everywhere that those speech codes, everywhere a speech code has been tested in court, it's been found to be unconstitutional. They're not allowed. But some people say, look, people say things that are harmful to me, and there is a line out there that the courts have drawn that says harm isn't necessarily psychological. I'm not the lawyer. I can't do that right for you. But there are limits on free speech, but it made me feel bad. Do corporations have free speech rights? So the big economic issue of the world has been corporations and their rights, and it turns out that corporations have free speech rights. And in fact, those free speech rights allow them to pick political candidates and give money to political candidates. And what this has done is allowed a whole lot more money to flow into elections through corporations set up and corporations giving to campaigns. And even though the law says we're supposed to be able to find out who gave the money, there's ways around that too. So this issue, and you have some readings on this, was the First Amendment meant to apply to corporations? And then when you have an election and you want to have a right to have a free election and have free speech in elections, how does this all apply? And it's really a complicated issue. The best example of Madison's fears coming to life is the Second Amendment. The Second Amendment says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. You don't get, if you talk to James Madison or Thomas Jefferson, you don't get the right to bear arms because the Second Amendment's there, and you don't lose the right to bear arms if the Second Amendment's not there. You have this right. The Second Amendment is used to terrify people one way or another when the Founding Fathers were concerned with tyranny. That was their big deal. They didn't want to live under a tyrant. They didn't want to live under George III anymore. They were afraid of the federal government having an army. And they felt the best way to prevent the federal government from getting out of control was to have strong state militias and no standing army at the federal level. That's what the Second Amendment is about. Not your right to have weapons in your house to protect your house. You get to do that. I get to do that. And nobody's coming to my house and disarming me. I get to do that. And it's not the Second Amendment that gives me that right. But what's happened in our world is what Madison feared, which is people have come to believe that the Second Amendment is the thing that gives them this right. And again, all rights are subject to interference with other people's rights. So I have a right to my own personal safety and my own thing, and you have a right to your own defense and your own thing. But those two things can come into conflict. So the state has a responsibility to keep us all safe. So again, here's Antonin Scalia. He wrote the definitive Supreme Court decision on weapons, and this is a paraphrase. It's not an exact word for word quote, but it's the only quote I could find that has a picture of him. So it says, like most rights, the Second Amendment is not unlimited. That is a direct quote. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. So that last sentence is actually part of a longer sentence where he talks about courts for hundreds of years have said that it's not a right that it's not a right to keep and carry anyone in any manner whatsoever for whatever purpose whatsoever. Okay? The District of Columbia, Washington, D.C., passed a law that basically banned firearms. Without permission of the government, you could not have a weapon in your house. And that case went to the Supreme Court. Okay? And the law in District D.C. is thrown out. The Supreme Court says that law is not a valid law. So the interesting thing about this case, and you get to read it or part of it, is that it's mostly about grammar. And various English professors have said, no, the interpretation of grammar here is wrong. But anyway, there's what Scalia calls a prefatory clause and what he calls the operative clause. So a well-regulated militia being necessary to secure the peace state is a prefatory clause. There aren't those in the Constitution. This is the only place where they put one of those. That clause is the purpose. So Scalia says this prefatory clause tells you the purpose of the amendment is to create the militia, to make sure that a state can have a militia. That's what this amendment's about. That's the prefatory clause. And again, it's the only one in the Constitution. How does that limit the implementation? Well, the operative clause, the right of the people to keep and bear arms shall not be infringed, Scalia sends pages after pages arguing that the prefatory clause doesn't affect the meaning of the operative clause. It's like it's not even there. And again, we can get into the grammar argument, but it doesn't matter. It doesn't really matter in the Madison sense. But that's the big argument, is whether the first clause, which even Scalia says is the purpose of this amendment, whether it affects the outcome of this amendment. Okay, so again, there's no other phrase in the Constitution that's regarded as not being operative in some way. Only that one phrase. The Supreme Court said, we hold that the district's ban on handgun possession in the home violates the Second Amendment, as does its prohibition against rendering any lawful firearm in the home operable for the purpose of immediate self-defense. You can have a weapon in your house to defend yourself. And really, if you read this argument and you read the Founding Fathers, you don't need the Second Amendment for that. Right? You can defend yourself. You're allowed to defend your property, your home and your property. But remember that there it said lawful. Okay? I have no interest in owning a speedboat, but I would really love to have my own battleship. But I can't, because the weapons on a battleship are not lawful for me to own as a private citizen. Although we do not undertake an exhaustive historical analysis of the full scope of the Second Amendment, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons or the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. Nothing in our opinion should be taken to cast doubt. Because I have a right to safety, I have a right that criminals should not be allowed. People who've been convicted of crimes in the past should be barred from carrying firearms now. That mentally ill people shouldn't be armed. That schools shouldn't be places where people have guns. And that we should be able to have conditions and qualifications on the sale of arms. All of those things are perfectly within the Constitution because no right is absolute. And again, this goes back to economics, externalities, this whole deal about, costs and benefits and no free lunches and all tied up in this. Once you make one right unlimited, then you're going to create all kinds of consequences that step on other people's rights. And so courts always have this problem, just like economists do, of trying to balance the costs and the benefits. Third Amendment is boring. It just says we can't put soldiers in your house in time of peace, and to do it during a war, we'd have to do it prescribed by law. The British used to make U.S. people put up British soldiers. So instead of the British paying the cost of housing their soldiers, Americans had to put up with British soldiers living in their houses. So the Constitution says none of that. Fourth Amendment. The Fourth Amendment, the right of the people to be secure in their persons, houses, papers, there's just unreasonable searches and seizures and requires warrants to be supported by probable cause, oaths or affirmations, describe the place to be searched and the persons or things to be seized. Now we've got lots of exemptions to this. The Fourth and the Fifth and the Sixth and the Seventh and the Eighth are all about crimes and criminals and criminal behavior. So the Fourth Amendment tries to protect us against searches and seizures. It has, can the police in the modern age sit outside with an infrared system and look at your house and watch you walk around your house on an infrared? Is that an unreasonable search or is that legal? Can they look in the window of your house? Can your neighbor look in the window of your house and take pictures of you? There's unreasonable search and seizure. If the police pull you over because you're speeding, can they search your car? So there's all kinds of issues tied up in these words. And again, the Founding Fathers thought that you had all these rights, but it became really important that we write these things down. Fifth, taking the Fifth. We hear that all the time. They took the Fifth, right? In the Mueller investigation, people took the Fifth. No person shall be held to answer for a capital or otherwise infamous crime unless present indictment of a grand jury, except in casual or militia, in actual such time of war. So, if you're going to be put to death, maybe you have to be indicted by a grand jury, unless you're in the military. You can't be tried more than once for the same offense, called double jeopardy. You can't be forced to take the stand, be a witness against yourself. You may not be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So we already talked about the takings clause, which is the very last part of this. Nor shall private property be taken without just compensation. If they want to build a road, they have to pay you to take that land, which is in your road. And again, no decide to life, liberty, or property without due process of law. We've had, turns out that little town sheriff departments all over America were funding themselves by seizing property of people who came through and then selling it. So people would get arrested for something, and all of the property that they had with them would just be would be seized and sold. And those things have been generally found now to be illegal. And it doesn't mean that it still doesn't happen, but these whole issues of defending your life, liberty, and property, right? That's what the Constitution is about. It's about you have these unalienable rights, these natural rights. trial. Sixth Amendment, speedy trial. Lots of people get arrested and spend a year in jail waiting for trial, only to be found innocent, and then the state goes, sorry about that. Impartial jury of the state and district wherein the crime shall be been committed. It is incredibly difficult to find an actual impartial jury of your peers. Very, very, very difficult. And there's all kinds of issues around that. And be informed of the nature and cause. So you get to be informed of the nature and cause of the accusation against you, to be confronted with the witnesses against you, and to have a compulsory process for obtaining witnesses. In other words, you can issue a subpoena the witnesses, and then you get assistance of counsel for your defense. So all these provisions within the Sixth Amendment mean that if you get arrested for some criminal offense, you're suspected of something, you get a speedy trial. It happens in public. It goes in front of a jury. You get to know exactly what you're being accused of. You get to confront the witnesses against you. You can force people who might testify in your favor to come in, and you get the assistance of counsel in your defense. And again, we'll talk about. So in civil suits, you also get to have a trial by jury, and the facts ascertained in that case cannot be re-examined. So once, if you are found that asbestos caused your cancer, no other court can go in and rule that asbestos did not cause your cancer. Other courts can examine the amount of money you won, and very frequently in civil cases, the amount of money that the person is eventually going to win is going to be reduced substantially by a judge. A woman got burned by coffee. She got a coffee in the drive-through lane at McDonald's, put it between her legs, and it went flying out and burned her. A jury said somehow that McDonald's was at fault for that and awarded her $6 million. She never collected the whole $6 million. It was way cut back, and McDonald's on their cups, writes, don't, put this hot, right? Hot. Don't spill it on yourself. A lot of things that sometimes a jury sees a person is walking down the street in the middle of winter. There's ice on the sidewalk. It's 6 o'clock in the morning. They slip and fall. They sue the place and say, well, I didn't know there was going to be ice, even though common sense would tell you there should be ice because it's the winter and it's cold in there. So you can't dispute the fact, but you can dispute the amount. No excessive bail, no excessive fines, no cruel or unusual punishments. There used to be, public floggings in the street, and that was not considered cruel or unusual. Now it is. The death penalty used to apply to many more crimes than it applies to now. It only applies to first-degree murder now, and then only under certain conditions. So these things change over time. But no excessive bail, no excessive fines, and no cruel or unusual punishment. So, us economists have studied crime. What a surprise, yes? We have studied crime, and we study it from the sense of what are the incentives, right? That's what economists worry about, is incentives. Police, their incentive is to find the bad guy as quick as they can and convince people that they found the bad guy. The court system has an incentive to try to convict that person. So that's why we have things like Miranda rights and public defenders, and you're constantly, if you watch the news, that every few months some person gets let out of jail who's been in jail 20 or 30 years for a crime they didn't commit, and the police did something really wrong 20 or 30 years ago on purpose, or just because they were under a lot of pressure to do something. And it's not saying police are bad people. I have friends who are police people. They're not bad people. They're good people. Police have an incentive to try to get the conviction. So it's okay for police, for example, to lie to you. If they bring you in and question you, they can lie to you to try to get you to say something. Once you ask for a lawyer, they're supposed to shut up and not ask you any questions. But so there are all these rules they have to follow. They have to give you Miranda warnings. They have to do this stuff because, again, not because they're bad people, but because they want to find the person. If somebody commits a crime and does a bad thing, they want to find that person. And you're right there with them. Find that person. Unfortunately, a big percentage of the time, relative to what it should be. Remember that the theory of American jurisprudence is it's better for 20 guilty people to go free than it is for one innocent person to be found guilty, right? Innocent unless proven. But the fact is that it tends to go the other way. And we know from study after study after study that the criminal justice system treats poor people differently than it treats rich people. If you saw you're not probably old enough to have seen the original O.J. Simpson trial, but he's rich. He can get a dozen of the best lawyers in the country and all of their staffs to work on his behalf, where if you're a poor person, you're sitting there with some public defender who's underpaid and probably 2 years out of college, and, you're probably going to jail. So there's the system. The system is not, as we study it, the system is not fair across all groups, and it has some bad incentives in it. At the same time, and again, that's why the Fourth Amendment, the Fifth Amendment, Sixth Amendment, Seventh Amendment, and Eighth Amendment are there, because the Founding Fathers recognized that the police know the law, you don't. You don't necessarily know your rights. You don't, right? The system isn't going to be balanced necessarily. And so the Fourth, Fifth, Sixth, Seventh, and Eighth Amendments are there to create a balance for you, the normal person, against the state, which has a great deal of power. Okay? Economists have also found that bad guys are affected by the probability that they get caught, not by penalties. Increasing penalties, making penalties more severe, does not have any effect on crime, because bad guys don't normally think they're going to get caught. So they don't care about the penalty. They're not thinking about the penalty. You do bad things if you think you're going to get caught. How many times when you were a little kid did you do something because you know mom was never going to find, or you thought mom was never going to find out? People do things when they don't think they're going to get caught. So the way to stop crime, well, there's two ways to stop crime. One is increase the probability that people are going to get caught. The other way is to get people to get older. The crime rate in the United States is down dramatically compared to 20 years ago. I mean, a lot. There's a lot less murders, a lot less violent crime, a lot less crime across the board. And that's because the population's gotten older. Young people, there's two theories. One is that young people commit more crimes. The other is that young people just get caught more often, and that old criminals are smarter criminals, and they get caught less. But either way, as the population gets older, crime rates go down. But you can't really make everybody get old. So what you want to do if you actually want to stop crime is increase the chance of people getting caught. So what do? We put up cameras everywhere. We do surveillance. We have drones. We have, and yet we have other amendments that say you have a right to privacy and you have a right. So now we get other rights that are in question, other rights that are in balance. If you go to many countries in Europe, basically every street in London's on a camera. Every word you say, if you have like an Alexa in your house, every word you say goes through that Alexa, every single word you say. And people have been caught doing bad things because the government was able to subpoena their Alexa records, basically, and find out that they'd been talking about whatever bad thing they were supposed to be talking about. You have rights, and as technology improves, is that should your right to privacy be surrendered to increase the probability of catching bad guys? So again, externalities, trade-offs, costs and benefits. This is why economics is so wonderful. It gives us all, it doesn't necessarily give us answers to these questions, but it gives us these questions. And off we go to the 9th and 10th, which are fun amendments.